Let me tell you 3 vital mistakes that I've seen recently that you don't have to make. Hi, my name is Bart Baggett. I'm a forensic document examiner. I'm actually leaving a courthouse right now in an unnamed city in California where the attorney in this case made all the mistakes that you shouldn't make. So if you are fighting a will and testament case and the will is at the courthouse and that authenticity of the will is in question, which means who wrote it, who's the author, is it a forgery or not, that's an essential part of whether you're going to win this case or not. Let me tell you 3 vital mistakes that I've seen recently that you don't have to make. One, make sure that the inspection is available weeks ahead of the trial so the examiner has time to do exhibits. Two, make sure the court order, especially in California where it requires a court order for an expert to examine a will, make sure the court order includes non-destructive testing, examination with a microscope, scanning, and photographs. The courthouse I just left, I was not allowed to take photographs. I was not allowed to scan the document. Therefore, me, the expert, and the other expert, if there's one on the case, will have to go to court and testify on what we saw, and we'll have no images to show the jury or the judge in this case. That is sad. Now, what we can tell from examining it with our own eyes is we can tell that it's wet ink on paper versus a photocopy, right? I had a microscope. I had machines. I was not allowed to use any of it because the court order didn't say you couldn't do it, but it didn't say you could. So it was too ambiguous, and therefore the clerk talked to the sitting judge up there that was on duty and said, hey, you know what? It doesn't say specifically they can take pictures, therefore they can't. So that's one mistake, very, very big mistake, is making sure both examiners has plenty of time to look at the documents and not a week before trial. Because if you had an error like this, it's hard to fix it before the trial starts. Secondly, make sure that you have an examiner designated within the designation time. Now, this is something you obviously know if you're an attorney because designation is important, but they need time to not only do the work, but the other side need time to depose that person with their valid opinions. So even though I was designated in plenty of time for this case, they haven't taken my deposition yet. And if they hadn't taken my deposition, it wouldn't have been very helpful because I hadn't had time to look at the original because they didn't submit the paperwork in time. Now, in states like Texas and Florida and certain states, you don't need a judge's signature to access the original will, which is weird because people could destroy wills, they could erase it. I know clerks sometimes just take their finger and smudge to make sure it's wet. All those things can damage the document, and we want to know if the document is wet. And so for most cases, especially in will and testament cases, one of the criteria for even accepting the will is it must be the original, which means it's wet ink. Wet ink is a misnomer. It could be ink that was written by a human but dried 20 years ago. Wet ink opposed to a photocopy. And I have seen a will and testament at the Los Angeles courthouse, which another examiner, an older one, yet she was in her 80s, but still, she shouldn't have made this mistake. She said this is an original signature. And under a microscope, I could easily tell in about 2 seconds that it was a color printout. You had the little inkjet spots, like spray paint. It's very easy to tell that if you have a microscope. So either she's not good at her job, or she was, I'm sure she's dead now, this is 20 years ago, or she didn't even use a microscope to confirm that it was a photocopy. Because a photocopy or a color printout is very hard to trace the lineage because we don't know where that signature came from. So will and testament cases really fall upon the wet ink, the ability to analyze the small striations, the ink spots, looking for pen lifts, and we can only do that if we have access to the original and if we have time to take pictures and put together some kind of demonstrative exhibit. Now, if we don't take pictures, like today, I can still go to court and testify on what I saw, but it's not near as impactful as if you have full color diagrams to show the judge, this is what I think is a pen lift, here's why, and it's in full color, right? So the 3 major mistakes I see in will and testament cases made by attorneys are they wait too long to designate an expert, to choose somebody. They hire the wrong expert, meaning someone who is not articulate, they can't go to trial, they can't create good exhibits with nice photography. And 3, they do not get the inspection protocol correct, so they miss the deadlines, the person can't take photographs, and then they don't have exhibits at trial because they waited too late. All those things can be avoided. Just talk to a court-qualified forensic expert, and none of these would happen with you as long as you're not coming in to the case at the last minute. That's when mistakes happen, is when things are being rushed, when things are being rushed to trial, when people get excluded because they were designated time. All that happens and really, really common. My name is Bart Baggett. Thanks for watching. If you like this video, like and subscribe. I post videos about the law, about forensics, about the legal processes, and specifically expert witness material, which can help you win more lawsuits. I appreciate it. Have a great day.